Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case.
Is that correct?
Literally not true.
Alrighty, I thought I was going to be done for the day. I thought we were going to be done, but we're back. We're back. There's a surprise filing. The judge beat the deadline. New documents in the Maya case just barely dropped. I want to give a big shout out to both Lauren and Amber for getting those to me with the ink still fresh. It has not dried. Oh my goodness. Let's see. Kindle's Life Owen. I never want to be a juror on a big case. We're gonna go into exactly why we never want to be a juror on a big case. But first, we have to say a big shout out to. Oh, I didn't have you on the screen, Kindles. Sorry about that. There you are. There's your comment. A big shout out to a couple people. Oh my goodness. First of all, Uncivil Law and the Uncivilians just joined. Thank you very much for rating us. Sorry, the music's a little loud. We'll turn it down here a little bit. Thank you, Kurt. It's wonderful to have you on yours with us. Also, roll tape, says Amber. She was first in chat, and that was her comment. It's amazing when you could get a legible comment in chat first. But you won the internet with that comment. Congratulations, Amber. The internet is all yours to take care of, which is important because we're going to kick it off right away with this document. Not a lot of stalling on our part because we're ready to go. Let's see. Let's bring it up full screen. Make sure it's going to be a continuous scroll. There we go. All right. This is crazy. This is crazy. First of all, a couple more other things. AKA the Cat Lady, thank you very much for your continued support. Look at that blue courthouse by your name. Thank you. Also, we have Patty Booth, who just joined us in the gallery. Thank you, brand new member, Patty. Welcome. Once you're here, you can never leave. I'm not sure if we told you that before you joined, but now you know. So here we go. We have the latest documents that just barely dropped. Let me go right here. There we go. In the Maya case, and the big one right here is on the top. The order permitting limited juror interview. You heard that right. The judge has gone ahead and said we're going to do it. We're going to bring in juror number 1 for a limited interview, and we're going to go over his reasoning that he spells out in here, and maybe also some of the limitations that might be on there. And we've got 4 other documents that dropped as well. And one of them involves J Hatch bringing in some new hired guns. So we're gonna look at all those just briefly, but this is going to be our main focus here. So let's begin. I will tell you that for those asking, I did run to the store and got Mrs. R.A. Some tomato basil soup and some crackers. She's happy, she's warm, she's resting. She's not feeling well, so she'll be feeling better soon, hopefully. So a big thank you to her for letting me do this. Order permitting limited juror interview. This is from the judge. Uncivil is very mad, very mad. This is super frustrating. This is really frustrating. The impact this will have. I'm going to let Kurt go into that a little bit from a legal perspective. Crazy by Proxy says this is just plain dirty. Let me go into the reasoning because I've skimmed through this and I've read through this, but I want to see the rest. The jury in this case has rendered its verdict against defendant Johns Hopkins All Children's Hospital in both the compensatory and punitive damages phases. The defendant filed its motion seeking a new trial based on alleged juror misconduct of juror number 1, requesting a juror interview together with an expansive discovery. Defendant has supplemented that motion 3 times in writing. The plaintiffs responded in opposition 4 times. The defendant's motion weaves together several alleged violations of the court's instructions or misstatements on the juror's questionnaire. During argument, defendant contends that while each in isolation may not rise to the level of requiring a juror interview, the cumulative nature of them, all of them together, according to the defendant, shows a predisposition on the part of juror number 1 to violate the court's orders which had a material effect on the verdict. That's important. They have to be able to prove that if they want the juror interview. The foundation of much of defendant's motion is defendant's continued insistence that juror number one's questions of witnesses during trial showed bias against the defendant. The court previously decided that issue in adverse to the defendant, meaning the judge ruled on this already the other direction. Now he's sort of reversing it. Plaintiffs contend that no juror interview should be permitted. In summary, plaintiffs contend that defendant did not meet the standard for a juror interview and that defendant is too late with their complaints. Plaintiffs suggest that defendant's basis for the juror interview is based on rampant speculation. Plaintiffs also present contrary evidence disputing the theme of the defendant's motion. Florida Rule of Civil Procedure governs the request for juror interviews in a civil case. The rule provides this. This is the rule that the judge has to follow. Interview of a juror. A party who believes that grounds for legal challenge to a verdict exist may move for an order permitting an interview of a juror or jurors to determine whether the verdict is subject to the challenge. The motion must be served within 15 days after rendition of the verdict unless good cause is shown for the failure to make the motion within that time. The motion must state the name and address of each juror to be interviewed and the grounds for the challenge that the party believes may exist. After notice and hearing, the trial judge must enter an order denying the motion or permitting the interview. Those are the two options the judge has, deny or permit. If the interview is permitted, the court may prescribe the place, manner, conditions, and scope of the interview. The judge goes on. Although trial courts should be hesitant to grant motions for post-trial juror interviews, such interviews are proper where there are reasonable grounds to believe misconduct has occurred. And this is case law. The second district summarized the general standard applicable to a motion for a new trial based on juror misconduct. And they said, an inquiry is not permitted unless the moving party has made sworn factual allegations that, if true, would require the trial court to order a new trial using the standard adopted. Under the Hamilton standard, the moving party must first establish actual juror misconduct. They have to establish actual juror misconduct. The movement is entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. My question is, have they established actual juror misconduct? I would say no. I've not seen that they've said that the juror has done something wrong, that they've proved this, that the juror has done something wrong. Let's see. Beyond disappointed, said Renee. Yes, this is... Jules, I hate everything. I'm sorry, Kurt. I should have. Oh, man. Okay. All right. Let's see. We've got more case law. Juror interviews are only appropriate only to investigate matters intrinsic to the verdict. Inquiry into the individual thought processes, calculations, or judgments of the jurors is prohibited. You can't say, so tell us about deliberations, right? Tell us about deliberations. You can't go there. They can. It's very limited to what they can ask. In order to constitute juror misconduct, and therefore a matter intrinsic to the verdict, sufficient to set aside the verdict or for a post-trial inquiry, Florida and other courts have consistently held that some objective act must have been committed by or in the presence of the jury or a juror which compromised the integrity of the fact-finding process. I don't see this. Even in their wild speculation. And just backing up a little bit. The judge, by granting this, is basically acknowledging that if this interview shows that what they said is true, he would by default have to order a new trial. That's what I'm reading here, because he can only grant it if the allegations, if true, would require that, and he's granted it. So that shows where we are right now. That shows where we are. Okay. A motion for juror interview need not conclusively establish juror misconduct. The moving party must only establish a basis for the inquiry. So that wording is much broader. Where there is sufficient basis for inquiry, it is appropriate to grant a juror interview, allowing the moving party an opportunity to prove, if possible, an entitlement to relief based on the allegations. So those wordings are much broader than the initial one we read, where they said they had to prove something was wrong. As the court noted before the trial, this is a case of intense public interest. It has generated significant media attention over the span of years, locally, nationally, and internationally. The media coverage has consisted of newspaper and television accounts, and very recently, a national magazine article, print and online, a streaming movie on Netflix released June 19th, 2023, podcasts, a potential book, and other comprehensive print, television, and online coverage. That's us. News accounts detail that as of July 3rd, 2023, the movie has been streamed more than 10 million times internationally, and it reached as high as number 2 on Netflix U.S. movies category. And so here we have the order directing the clerk of court to limit release of juror information rendered July 17th. Attending the trial daily were members of traditional media, as well as members of various internet communities who reported on the trial to viewers on various platforms. There were 2 media cameras in the courtroom each day. This was during the jury selection. Two media cameras in the courtroom each day, beginning with opening statements. And this feed was broadcast in real time on the internet and picked up by various internet shows, either live or in recaps. Additionally, the court operated a Zoom webinar with 4 different camera angles, and members of the public were allowed to access, but not rebroadcast, the court's Zoom webinar feed. Parenthetically, members of the media attended both the individual questioning and group questioning of prospective jurors, but the media chose not to broadcast jury selection. The court also had an overflow courtroom so that additional members of the public could attend jury selection. The court notes the daily broadcast of the courtroom proceedings to give context to the court notes the daily broadcast of the courtroom proceedings to give context to the motion and response. Plaintiffs allege that some portions of the defendant's argument are based on investigations conducted at defendant's request by various internet communities favorable to the defendant. Defendant has not denied that belief, but has not expressly agreed to it either. They're talking about Reddit here. Shapiro, Reddit. That's between the lines. The court will later address a concern about either side deputizing an online community to take actions that the party cannot do itself. Whoa. That approaches sanctions right there. Like the judge is, implementing sanctions on his own. Much of the defendant's initial motion focuses on the alleged allegations or the alleged actions of juror number 1's spouse. Defendant motion states that juror number 1's spouse attended the trial on October 30th. Defendant points to screen captures from the media feed that depict a woman believed to be juror number 1's spouse talking with another person in the gallery, whom defendant identifies as Jules, who apparently has her own online show on TikTok. She's notorious. She's an Agent Jules on TikTok, and who would call into other online programs on YouTube, say like Law and Lumber or our own. Defendant contends that Jules was pro-plaintiff, going so far as accusing Jules as being a plaintiff's agent. Defendant's suggestion that Jules was plaintiff's agent is mostly conjecture. Attorney Greg Anderson issued an affidavit rejecting that Jules was plaintiff's agent. Defendant also points to social media posts during the trial made by an online account that has been attributed to juror number 1's spouse. Defendant argues that juror number 1's spouse heavily was pro-plaintiff's. To suggest juror misconduct, defendant baldly asserts, it strains credulity to believe that juror number 1 and his spouse were not discussing the case in violation of this court's instruction. Defendant seeks to piece together occurrences in the trial to suggest there must have been discussions between them. In reviewing the posts attributed to juror number 1's spouse objectively, though, the court observes that they are not necessarily indicative of improper communication or other misconduct. Kurt, thanks for holding your tongue a little bit. There were, however, constant instructions to the jury not to discuss the case with anyone, not to receive any information about the case outside the courtroom, and not to investigate any aspect of the case. There were also instructions not to review any media coverage of the case, and the jurors were instructed to report anyone attempting to approach the jurors. While defendant's assumption that juror number 1 and his spouse spoke about the case certainly is not evidence, the court concludes under these very unique facts that defendant has made a sufficient showing for an interview of juror number 1. I skipped a paragraph. Sorry. I skipped. Regardless if there were no court instructions that restrained any juror's family member, there were no court instructions that restrained any juror's family member from watching the trial or publicly expressing their view about the case. In this context, the court currently does not believe it necessary to interview juror number 1's spouse. That's important. The spouse, hippo lover, you're safe. But the court concludes that there's a limited juror interview is appropriate for this case of juror number 1. Where an interview is permitted, the rule provides the court may prescribe the place, manner, and conditions and scope of the interview. There is some authority that would be public and media. There is some authority that would permit the court to allow the juror interview to occur in private, outside the presence of the public and media. Counsel has the right to be present during the interview, as well as to retain a court reporter to report the proceeding. The court, instead of counsel, may conduct the interview. Case law prohibits any inquiry into any matter that inheres in the verdict itself. Putting this more directly, juror number one's thought process about the evidence and juror number one's discussions with other jurors during their deliberation are not proper subjects of a juror interview and will not be allowed. Juror number one's position, if any, with respect to the case for or against any party is beside the point. The issue are whether juror number one engaged in the misconduct alleged. This interview, though, will not include each topic contained in the motion of the supplements. The court will not address with juror number one the matter involved in the second supplement. In this second supplement, the defendant points to juror number one's handwriting on October 12th. On October 12th, 2023, the juror question. Defendant posits. An excerpt from the website of Simon Wiesenthal Center documenting the appearance of a uniform badge of the Nazi German Schutzstaffel, or SS, is attached. It will be noted that in the Exhibit A, juror number one has printed the letter S throughout the note normally, with a curve in the spine, except that he printed his S with sharp angles when printing Dr. Sally Smith's name. Both the second and the third times that the juror number one prints Dr. Sally Smith's name, the letter S is shaped in a manner identical to the symbol of the Nazi SS exhibited in Exhibit B. Printing the first letter of Dr. Smith's first and last name in this manner makes it clear juror number one's bias and prejudice against Dr. Smith, and thus the defendant, equating Dr. Smith to a notorious Nazi organization. In addition, juror number one, on October 10th, printed Exhibit C, in which he effectively prejudged the relationship between defendant and Dr. Smith, equating one with the other. This issue is waived, or untimely, or both, for at least two separate independent reasons. So they're not going into the SS. Okay. Sorry, I'm seeing some really funny comments in chat. First, these are the reasons why it's waived or untimely. The defendant saw juror number one's handwriting on that juror question when it was asked, and in fact had a copy of it during the trial. The court, after reviewing each question, handed the attorneys the actual question written by each juror, meaning each attorney could visualize the handwriting. Further, during the trial, the defendant asked for, and the court arranged for the defendant to obtain all juror questions, including juror number one's question during trial. Defendant did not raise in its motion to disqualify juror number one made during trial or at any time before the second supplement any suggestion that juror number one equated Dr. Smith to being a Nazi. Second, defendant filed the second supplement more than 15 days after the jury verdict. The rule requires the defendant to include in its grounds in its motion that had to be served within 15 days after the rendition of the verdict. This 15-day rule implements the strong public policy against allowing litigants either to harass jurors or to upset a verdict by attempting to ascertain some improper motive underlying it. That the second supplemental issue is either waived or untimely or both means the court does not need at this time to evaluate whether the defendant had good faith basis when counsel signed and filled the second supplement. To be clear, the court is not reaching that issue. The court does, though, caution all counsel for deputizing an internet community to do indirectly that which an attorney is expressly prohibited to do directly. Florida Rule of Professional Conduct, which previously has been found to be constitutional, prohibits attorneys from having direct or indirect post-trial communications with jurors in a civil case, except as outlined in Rule 1.431. The court also will not address with juror number one the matter involved in the third supplement. In that supplement, the defendant claims juror number one falsely answered during the voir dire that he had not previously been a victim of a crime. Defendant only recently has provided documents indicating juror number one sought and received an injunction for protection against repeat violence in Charlotte County, Florida in 2016. Defendant asserts it learned this information after entry of the verdict, but this third supplement raising this claim was filed several weeks after the 15-day deadline under the rule and does not attempt to show good cause for this delay. Accordingly, the claim is untimely. It's too late. You can't go there. The court believes that an interview of juror number one is sufficient to address the issues raised by defendant, and there is no need for invasive discovery such as forensic searches of phones or computers. The only topics on which the court will permit the interview of juror number one are: Whether juror number 1 received or shared information about the subject matter of the trial through outside sources, including his spouse. Whether juror number 1 conducted an investigation about the subject matter of the trial, including looking up websites. Juror number 1's knowledge of Deborah Salisbury, if any, at the time juror number 1 completed the supplemental questionnaire. That was the lawyer that may have known his wife or participated in one of the wife's proceedings. And whether juror number 1 had undisclosed opinion concerning DCF during jury selection, and whether and to what extent juror number 1 and DCF or any prior entity were involved in Broward County Circuit Case Number FMCE 2016-257. In this case, so those are the 4 questions, the 4 areas they're allowed to go into. In this case, the court will decline to interview juror number 1 in a place other than open court. This will happen publicly. Public confidence in the process is important, and the court will therefore conduct the interview in open court. The court will be the person to ask the questions of juror number 1. After the court has completed its questions, the court will permit the parties to suggest to the court additional concepts that the court may ask juror number 1. It is therefore ordered. The court will allow limited juror interview only on the topics identified in this order and under the conditions referenced in this order. The defendant is ordered immediately to send juror number 1 a subpoena via process server or sheriff, directing juror number 1 to attend to the juror interview, which is currently set for 3 p.m. on Wednesday, January 3rd, 2024, in courtroom 2A at the Silvertooth Judicial Center. That's where the same building we just had the last hearing at. Defendant shall also include in the service package of this copy of this order a copy of the notice of the hearing, a copy of the defendant's original motion for juror interview, and a copy of the first supplement to the motion. When defendant files the return of service and copy of the subpoena, the defendant shall file a notice of confidential information identifying the clerk to redact the address of juror number 1 anywhere in any of the papers filed. The defendant shall refer to this order directing the clerk to keep juror number 1's address exempt from public disclosure. This is nice that the judge does this because the defense did not when they filed that. So we have road trip. Man, let's see. There might be a cheaper flight. That might be an option. Hold tight. Don't do anything on that front. So this is done and ordered in Sarasota County, and it's signed by Judge Carroll. So here's what we know. If we can surmise this, the judge says basically most of what the defense threw at the wall, the SS, doesn't matter. They had their opportunity. They missed it. It doesn't matter. The judge is not looking into it. The only things he will look into, and he will allow a limited juror interview. It will be public. It will happen in front of the court. The media will be available to be there. The public will be able to view this as well. But juror number 1, and not juror number 1's wife, not Jules or anything else, will attend the hearing, will be sworn in to tell the truth, and they will ask questions in 4 areas. And those 4 questions are whether he shared any information about the subject matter through outside sources, including his spouse, whether he conducted any investigation, including looking up websites outside of trial, whether he knew Deborah Salisbury, and whether he had an undisclosed opinion concerning DCF, and if they were involved in a case that he's aware of that's in his past. Those are the 4 that have to go in. Once those questions are asked and the judge is finished, he's going to then allow the parties to suggest to the court questions to ask the juror, which the court may or may not ask. I am willing to bet you dollars to donuts the defense will have some suggestions. And I hope that the judge listens politely, nods, and gives them the finger. That's what I think. The finger is like this one, saying no, no, no. What do you guys think I meant? What do you think I meant? Oh my goodness. So Jules will not be interviewed. The juror's wife will not be interviewed. Jules' phone, the juror's wife's phone, and the juror's phone will not be forensically evaluated. All we're going to have is basically these 4 questions, or possibly a combination of questions that make up these 4 subject matter areas, and then responses. Whew. Wow. Who is Salisbury? Marcia. Salisbury is, I believe, before juror number 1 married his wife, and this is going into stuff that, people should be able to, not have their private lives just poured out on the internet, and this is prying into that. And I apologize. I'll try to be as sensitive as I can and as brief as I can. Before he married his wife, I believe, was involved in a divorce situation, and in that proceeding, one of the lawyers was Deborah Salisbury. Okay, so that happened. Then he marries his wife, and he's supposed to say, hey, you can't pick me as a juror because before I married my wife, she was in a court proceeding, and one of the people in the court, we don't even know if she represented the wife or the other party or what she did, or if she was just sitting there and did nothing, but one of them was Deborah Salisbury. I think that's a big nothing burger. I don't think anything will come of that. All right. This is the date. That date they picked of January 3rd. That is the date the judge sort of during the Friday hearing last week that he said basically, hey, are you guys going to be available on that day? That's the date he went with. It's going to be in the same courthouse, different courtroom. We were in, I think, 6A or 5A. I forget, 5B. Now we're going to be on the first floor instead, or the second floor. I'll warm up the Audi. Thanks, Adam. Appreciate it. That is, I can tell you, that would be a very, very long drive for an even shorter hearing. This hearing, if it lasts 30 minutes, I would be astounded. But it will be an open court. I was surprised about that. That blew me away. Misty Beard says the defense already said they wouldn't let it go. They want everything and won't stop harassing juror number one until they get it. Let me pull up one more document. We've got an order setting the court date. I just want to view this one really quickly and see what this is. This is the hearing. It's scheduled for an hour, so double my time, my expected time. Of course, we didn't even take the 4 hours we were supposed to on the last Friday, but so it might go quicker. But starting at 3 p.m., scheduled for 60 minutes, it is a juror interview. Is hearing evidentiary? Yes. Judge Carroll has a hybrid courtroom, which allows participants to either appear in person or via Zoom. For all non-evidentiary, sorry, I have to change the view here. So let's continue to scroll. There we go. For all non-evidentiary hearings, and for evidentiary hearings at 1 hour or less, each participant has the discretion to determine how that participant will appear. It's possible that the juror can appear via Zoom. For evidentiary hearings exceeding 1 hour, the participants must appear in person unless the court orders otherwise. We'll have to go back and see if he orders them in person to be there. And don't call the judge's judicial assistant because she's busy. Zoom webinar credentials are going to be provided. There are no fees for attending court via the Zoom platform. You can access it there. There's a link. Court proceedings are open to the public. Court reporters and digital court reporting. The court reporter, basically, if you want this recorded, the parties have to pay for it, and the party will. They will definitely pay for this. Defense is going to want every word of this documented. No recording proceedings. By rule and court order, you're not authorized to make your own audiovisual recording of court proceeding. No one may take screenshots or other audiovisual depictions of a court proceeding. Recording a court proceeding is strictly prohibited unless approved by the judge. If you violate these rules, you may be held in contempt of court. Members of the media must comply with Rule 2.54 or 2.450 and the Administrative Order 2020-23.2 regarding media coverage. That's what we do to get media access. Please contact the court's public information officer for further information. I will do that. Late entry and technical difficulties. You've got ADA interpreters done and ordered, signed by the judge. So this is just this is basically reserving the courtroom. That's all this paperwork is. It's the same information we have in the initial one, a little bit less so, but that gets us here. There were a couple other documents that were dropped here. Let's see if we can. Let's try this one. Okay, we have a verified motion for pro hoc vice. This is a motion filed by the defendant. The plaintiffs, by and through undersigned counsel, hereby moves the Honorable Court to deny the movement's alleged unopposed verified motion of admission pro hoc vice, and the grounds therefore would show. So they're moving to deny this. So let's open up what that is. This is pro hoc vice. This is Kerry J. Williams. Kerry J. Williams. He's in Baltimore, Maryland. He's not a resident of Florida. He's an attorney in Maryland. He's been retained by J. Hatch. Sorry, change the view so this will show up properly. He's an attorney retained by J. Hatch And he says, for the last 5 years, I've been good, right? I haven't had any black marks on my account as far as my bar record. I have no complaints against me. I practice here in Maryland, District of Columbia, Court of Appeals. Here's my bar number. And he's saying, what I want is for you to let me to practice law in Florida briefly, just on this case. Thank you. Do not suggest or promote any kind of harassing actions. Doing so risks a 24-hour timeout. Thank you, Amber. We have a very low threshold for anyone who suggests something like that. That's something we've never been part of or encouraged. So please be respectful of all the parties. So let's see. He says he's not a member of the Florida Bar. He's not a member. He was not inactive. He's not a member. He's not suspended member. And he's never been disbarred from Florida. But I would like to be able to practice in Florida, is what they say. So can you please, let's see, movement agrees to comply with the provisions of Florida rules of conduct. He says, I promise to behave. I respectfully request permission to appear in this court for this cause only. So this is what happens when you're not licensed to practice in a certain state, but you want to do something in one case. So this movement, this motion is that this guy, what's his name? Carrie Williams, or it could be a girl. I don't know, guy or girl. Carrie Williams wants to practice in Florida. Then there's a second motion as well, also for Mr. Derek Strikeleather. Same sort of thing. He's a Baltimore guy. He's got, I think, just basically copy and pasted the previous motion. Says he wants to come down. He's hired by J. Hatch to provide. He says no disciplinary. He's never been in Florida. Never been a member of Florida Bar. And he agrees to comply by the rules in Florida. And I respect the permission to appear in this court for this cause only. So that's Derek Strikeleather. He wants in. And so in response to this, the plaintiff has filed this motion saying that we move that you deny this unopposed verified motion for admission. Okay. The moving counsel has filed a motion in which the authors of the verified motion state that they filed it under oath not to misrepresent facts making this motion. They asserted that the motion is unopposed. At no time did the movement call, write, or text, otherwise contact plaintiff's counsel, especially the undersigned lead trial counsel, who has made it clear that no one but the undersigned has the authority to make decisions on behalf of the plaintiffs. Oh, my goodness. He's saying they lied in their motion because they said it was unopposed. They lied in their motion because they said it was unopposed. Sorry, this is the worst. Casey Cat says, this is breaking news, folks. Please show RA some respect and smash that like button like it's Shapiro. Oh, be nice. Be nice. Shapiro is a very, very talented attorney, and I'd love to interview him on the show. He just needs to get the burner number and call me. So they're saying they didn't warn us. They say this is an unopposed motion, so the judge should just grant it because the plaintiff isn't opposed. He says, wait, judge, I am opposed. It's misleading and false. We object. The motion is further deficient in not having been served upon the Florida Bar, nor does the movement certify that the applicable fees have been paid. For the foregoing reasons, the unopposed motion must be denied. Greg Anderson says, shut it down. We don't need two more J. Hatch lawyers coming down from Maryland to mess with this. But those are the five documents that just posted tonight. I tell you, I would love to interview Mr. Shapiro, and I would do my very darndest to be as respectful as I was with, say, for instance, Solomon Anderson, who I also disagreed with. Wait. Big Sky says, wait, stop. The top of page 3 says he was disciplined. Please go back to that. Let me look at this. This must have been the second guy. Let me go full screen here. This is Strikeleather, top of page 3. Movement has not previously been disciplined or held in contempt by reason of misconduct, committed while engaged in representation pursuant to Florida rule, except as provided below. So no, I'm seeing no. He has not been. He's not broken any rules. Yeah, it was a has not, and then the place to fill in where he has is blank. So I think he's good. He's in good standing. Let's see. Page 2, says Lauren. This is page 2. Active member in good standing. There have been no disciplinary, suspension, disbarment. I'm not seeing anything. Yeah, I'm seeing his clean. Basically, they have clean records the last 5 years, and that's as far as they go back when the court looks at a lawyer to see if they're good or bad. What have you done for me lately, right? What have you done in the last 5 years? Bottom of 2. I'm looking. I just don't see. Nor has movement received a disciplinary resignation or disciplinary revocation. So there's nothing. He's saying, all of them are saying, there have been no disciplinary proceedings against me through the Florida bar or anything that would cause problems for the court granting this. Now, apparently, I don't know the rules on this, but apparently this has to be filed with the Florida bar, and you can't just throw it up there willy-nilly. And let's see. Mathis says, everyone please relax. Did you do anything wrong? No. Okay. Nothing for the Court of Appeals to do. Baltimore lawyers hired November 3rd because of IJ? Possibly. This decision has reduced my trust in the juror system. He's willing to drag a juror in at best speculation, says Culperistic, but drags his feet on defense counsel, openly defying court orders and admitting it. Culperistic, I agree. The wording when we first read this, if you look at the first, looking at the order for the juror interview, I've got to go full screen because my old eyes just cannot see this. So look at this. Look at this section right here. Right, an inquiry is not permitted. Okay, an inquiry to a juror interview is not permitted unless the moving party has made sworn factual allegations that, if true, would require a trial court to order a new trial under the using the standard adopted. Okay, so I read that wrong the first time. So they have made allegations. They said that he's talked with his wife inappropriately. That could be grounds for a new trial. Here's this. Under the Hamilton standard, the moving party must first establish actual juror misconduct. Have they established actual juror misconduct? And I would say no. The best they've got is they've got the juror's wife doing proper conduct as a member of the public. That's the closest they get. What impact will this have on lawyers in general? Will they all try attracting jurors because it worked in this case? Case law and precedent is powerful, and if this is allowed to go forward, and if this fishing expedition is permitted, why would everyone else not also go on a fishing expedition? If we're allowed to, after the fact, go back and revisit things just because we didn't like how it ended up. Okay, imagine going to a soccer game, and cheering for your team, and your team's the best, they're the greatest. You're wearing their jersey, right? You know all the songs, you cheer, you clap, you buy the hot dog, you have a great time. Unfortunately, things don't go your way, and your team loses. And you go home, and you're like, that's just not fair. I want to go back and I want to research everything the other team ate for the last 3 weeks, and see if there's something in there that might have given them just an extra burst of energy that would not have been a fair grounds for me. I mean, it seems absurd that you can go back and try to relitigate something that has happened and closed, and it was done fairly, and it was done followed the process that we followed for years and years and years. And the judge is granting this in this one is. Honestly, it's scary. It's scary for anyone who receives a summons in the mail that says you're ordered to attend court for jury selection. Bring your ID and take the day off because you may or may not be seated on a trial that may or may not be the biggest trial of the country. It may be the biggest trial of the century. And guess what? If you are seated on that jury, we're going to, according to this, we're going to pick your life apart after the fact if we don't like the decision you made. Not good. I'd like for Ari to see my message. Recover it. I had to surrender my cats today. Oh, Pickles and Zoe, I am so sorry. I am so sorry. That's not good news. Uncivil law, you need to get to Florida ASAP. I don't know. I think at this point, I think it would be smart, it would be proper for juror number one to lawyer up. Not because he needs to hide anything, not because he's trying to not get caught doing something, but because this has gone from the realm of a juror doing their civic duty to someone being dragged through a judicial process that is much bigger than them. So I think lawyer up for sure would be the right suggestion for juror number one. And the juror is going to be shown all over the internet. Yes, it's going to be live in court. So this is there goes anonymity, right? It only takes just a little bit, unless the judge, and I didn't see it in the order, the judge did not order that the juror's face not be shown. Yeah, he's saying don't show the address, the juror's address, which the defense already did in their motion. Aaron says the other side of this is that the judge could be setting J Hatch for massive sanctions to stop dirty lawyering. Yes, that's also a possibility, but why would he grant that? If the judge right now is already saying this is absurd, if that's the position the judge takes at this moment with this whole juror interview, he's like, this is abuse of the system or whatever he wants to call it. Why would he grant it? Because I can tell you that the defense team is dancing right now. They're dancing on their 2 boxes of J Hatch documents in celebration because this was granted. All that's figurative, but all right. Man. So the breaking news is that the judge has granted the juror number one interview. It will be limited. It will happen in the judge's courtroom. It will be public, meaning the media is allowed to be there. It will be limited to 4 areas of questioning. Once those 4 areas of questioning are complete, then the judge will allow counsel on both sides to suggest to the judge, not directly to the juror number one, but suggest to the judge other areas of questioning, which the judge may or may not proceed with at that moment. Mrs. R.A. says, so to date, juror number one has been attacked in the following ways: privacy, his word of honor, financially. What else? What else? Now, his character has been attacked in a huge way. His penmanship has been attacked. Oh. When will the live happen? Portia Spencer, the live's going to happen on January 3rd. Let me see. I'm going to reach out to the court. I don't know. I'm not prepared to be the pool media cameraman on this one, but we'll see. We'll see what else happens. We'll see if this is something we can stream. Is it possible that they might be able to file a motion asking that the juror number one not be shown on camera? I believe that would be appropriate. I think that would come from the lawyer of juror number one, if that motion is correct, or possibly from the plaintiff's side. But I believe that the judge would, the judge should grant that if that was asked. Definitely say, and maybe juror number one says no, bring it. I don't know. Maybe he's like, I'd like to face everyone, and so you can look me in the eye when I tell you, and you can believe me. That may be the case. Will you be in the courtroom? That's not yet been decided. I haven't even talked to Mrs. R.A. She didn't even know what this was. What was happening here before. Like I said before, 13 hours is a long drive, especially for a 1-hour hearing. And I don't know. Maybe she wants to come with. Ben, thank you very much for the super chat. I appreciate that. Thank you. Good to have you as a wonderful supporter. I've never seen anything like this before. The defense are really sore losers. Ashley, we know that this has happened a couple times because I believe we have Mr. Elgett, who has at least twice before been involved in situations where there was a juror interview. I think he was the one that said he had some experience. The judge hasn't. I think this is the first time for Judge Carroll. I feel for any juror in a high-profile trial from now on, says Rachel Henderson, this precedent is dangerous. Ricky Watson, hello there, my friend. Good to have you here tonight. I hope Judge is reading chat and realizing he's doing damage to our system. He's got to be so careful, Julie. I mean, I realize he's caught between a rock and a hard place, and I think Ian and Rob from Law and Lumber both were sort of acknowledging this, that the judge sort of, with all the efforts he's made to make this appeal proof, he sort of allowed himself to get painted into a corner, so that now there's a cloud hanging over it. Now the cloud is not any evidence or wrongdoing, but there's a cloud of possibility, and it's possible something was wrong. And we got to this point for whatever reason, and now I think the judge had to grant that limited juror interview. I think he did, for the most part, I think he did it just right, other than the fact that that it's public. As much as I love to see court and like to participate in it and like to see what's going on for myself, I think that was the wrong decision. I think it should have been held privately. The fact that he did it publicly, I think, was most likely for the very reason he granted the juror interview in the first place, and that is so that there will be no perception of wrongdoing, so that nobody can say, oh, but what really happened in closed chambers. Oh, man. Plaintiff will suggest most important question, what did you have for breakfast? It's a dark day, says, let's see. This is dangerous ground, says Wolf PJW. Juror can't sue because it's from litigation. Yeah, the juror has no recourse to sue on this one. Amy Jones, how is it possible if the evidence does not meet the 3 questions? Is there any possibility of the juror 1 being charged with anything? Excuse me. I just saw what your name meant. Excuse me. No, I don't think there would be any charge. Even if the juror disregarded the judge's orders, I think the worst that he would get was a stern talking to from Judge Carroll, which can be pretty stern. We've got somebody calling in on the juror phone. Let's see if it's Mr. Shapiro.
Grassfolk.
Nope, it's not. It's Grassfolk. Grassfolk, how are you doing tonight?
I'm well. How are you?
Oh, I'm a little riled up, but other than that, doing pretty good.
Yeah, same. I wondered if we could have a chat about the line somewhere in the middle about the court having a go at addressing the parties about having internet researchers.
Oh, yes. Oh, this is right down here. Let me read this again, what you're getting to. The court will later address the concern about either side deputizing an online community to take actions that the party cannot do itself. Now he says either side on this, but I want to look at this and say what side did this occur on? Where did this occur? I can tell you it didn't happen here on our channel. We had no contact with any of the plaintiff's side until after the case was over. I know Rob Law and Lumber, the same thing. He's got a lot of respect for the law. He would not even tolerate the idea of go broaching that line. But where we did see it was where we have emails to Redditors saying, "Hey, keep doing this good stuff. Keep digging this up. Let me know." Ooh, that's sanctionable material, I think, right there, because the judge spells this out, saying you can't deputize somebody and have them do something that you don't have authority to do yourself. Right.
So what are the things that they don't have authority to do? They're not allowed to do. They're not allowed to contact the jurors.
Right.
What are the other things that what has the internet community done, both on Reddit or potentially in our chat?
Well, I would ask sort of chat to chime in on this, because even though this has happened, I've been aware of it. I haven't followed the Reddit feeds and what was going on. I know there's a lot of emails. I know I can name some names of people who could answer this question in a heartbeat. One of them emailed me today, but really there was just groups out there that were sort of like the long arm of the defense counsel in digging things up and getting access to private things that defense really couldn't do the way it was done. And so you think of how many times defense came up and said, the judge said, "Where did you get this?" He's like, "It was sent to me." A little bird whispered in my ear, and now I know this bit of information about what Maya did on her date last Friday. It's just absurd.
Yeah, because I suppose it's again like that perspective, because the plaintiff side have also commented that they were paying attention to chat and pulling stuff out, but I know that we didn't do anything visibly. So it's what are the things which are not appropriate. Was
the deputizing indicates that there was an action taken on the part of the attorneys to get those folks to do things for them, and that's where the problem is. So it's one thing to gather information, and that's perfectly allowable. Every lawyer in every court case that has media coverage would be stupid not to, pay close attention to what's going on out there and listening. But when you go out there and you hand out little honorary J-Hatch lawyer badges to people, that might be what the judge is talking about.
Well, I'm very frustrated about the whole thing. I'm with Kurt about the whacking stick, and I was listening to it hoping the judge was going to redeem himself in one way, like basically give with one hand but give them a solid slap with the other, and I didn't quite see that in the paper.
We're not going to see that, though. That's the catch. The judge has said when it comes to making a decision, this is the decision he'd make this week. He said he'd have it by Wednesday or Thursday, and we got it today. But he said, and I'm not going to make any other decisions until after we sort this out. It's first the juror interview, because everything else is decided on whether or not something happened or not. So once this is sorted out, once the third rolls around and the judge gets those 4 questions answered, if they're answered satisfactorily, and that we find out that juror number 1 did everything he said he did, which was follow the instructions of the judge and follow the law, then the judge gets to move on, and then we have sanctions. Then we have the issues that the defense has raised about lowering the amounts on some of the verdicts to in some areas, which I think the judge will hear. I would be surprised if it isn't lowered by at least $5 million. That's my call. Probably more.
It's because the plaintiff have even said, like, oh yeah, we don't really care about that one. You can drop that. That's fine. No worries. Forget it.
It's one little charge. But then the other thing is also the sanctions, and that this is something the plaintiff asked for a long time ago and has asked for over and over. These sanctions are probably going to be the last thing to happen, and the judge is going to punish everyone for their bad behavior. And
I don't know. Like I'm now with Kurt on this. That it just feels so. Like, I don't understand waiting till the end to be like, are you all done fighting amongst yourselves? Like, are you done being emotional? Okay, now what do you want me to do? It's like, well, what's the point of them if if the sanctions aren't going to make them do the things correctly the first time round, if you leave it right to the end? Like, I get the theory, but it's just so frustrating.
It is. It's a slow process, but I mean, you've got to look at this case. It took 5 years to get to this point.
Yeah,
right?
that's true.
So court is not necessarily we all want instant gratification, have justice now, right? When do we want it? Now.
Absolutely.
But a lot of it just takes time.
I think the 4 questions are really telling, though, like, because it's about the things that he potentially didn't put in his questionnaire, right? There's do you have an opinion about DCF that you didn't tell us about? Did you know this person when you didn't? Did you say what you said, and was it true? Cool, great.
Yeah.
So I think those ones are the ones which are just like, altogether it's annoying. But
Grass folk, thank you very much for your questions. Thanks for sharing your accent with us. We love it.
always lovely to hear you. You're an absolute joy. So
thank you. I think Jules is going to call in now, so we'll talk to her. Thank you so much.
Look forward to hearing her.
All right.
Cheers.
Bye. Bye. All right. I think Jules is trying to call in right now. We'll give her just a minute to see if she can get through, and she did.
Call from
Jules.
Hello, Jules. How are you doing?
Hey. Oh, I'm pissed.
Oh, man.
I am pissed.
Yep.
I'm sorry I'm using the word pissed.
We're using the English, like the American English version, not the British version.
Exactly.
It's worse over there. Same word, worse meaning.
Scott, listen, listen, I get that, well, no, I don't understand this at all. Excuse me. I just feel by granting the interview, and I understand that it's limited with those questions that the judge is going to ask. However, you read that he may entertain defense and plaintiffs to ask other questions as well. As far as I'm concerned, the jury system's broken. Judge Carroll broke it today. It's broken. No one is ever going to want to serve on a jury. I don't care how big or small the case is. It's just not going to happen. Also, and you tell me if you agree with me on this, by them doing this to the juror, and once his information is out there now, and especially if they show him on camera, so wrong. But we don't know if this man has a job or not. I understand he's retired law enforcement, but does he actually have a job, or what if he's seeking employment? This whole thing can ruin this man's life.
Oh, I can tell you, there are so many situations where a company would look at somebody and say, we don't want to have an employee that just has a lot of attention on them, because if it goes bad, it would look bad for us, even without doing anything wrong. And so, yeah, this could be very, very harmful to proceed the way this is. I hope that juror number one, A, lawyers up, and B, files a motion to say, hey, I'll show up in court, but I believe that I have a right to request that my identity is not shown, my face is not shown. Because it's one thing for the judge to say, hey, redact the address out of the courtroom. But anybody with a smartphone can take a screenshot and do a reverse image lookup and track back and see who it is. I mean, to put one and one together, it's very simple nowadays to actually find out who that picture of somebody is, or to publicize it, or say, hey, I'll pay $50 for the person who tells me who this is. I mean, the internet goes nuts over crazy stuff like that, and I think it's so wrong to show that.
And you were there in court where Shapiro does a little sidestep around the whole Reddit thing.
Someone told me.
As a matter of fact,
someone told me.
Yeah, someone told me. I sent you, because someone sent me a screenshot, and I just sent it to you about 5 minutes ago, where someone from Reddit was telling all of their people, don't overwhelm the lawyers, with all of your information. Mr. Shapiro is very much aware. I sent it to you. Yeah, you have it. And I think I'd have to go back through the motions, but I'm hoping that you remember. Mm-hmm. Did Greg Anderson not state and also put exhibits, his own screenshots in there of emails from Shapiro to the Reddit group and acknowledge that the information was coming from Reddit?
I believe there are some emails. I believe there's an email, one from a Clark Kent attorney. Can't remember his name. David Hughes, and one from Shapiro, I believe, that are in the record that seem to be tied to people on social media who are providing information. That's my recollection of that.
That's what I thought. So I just have no idea where this is going to go. I think it's an extreme invasion of privacy. I honestly did not think that Judge Carroll was going to do this. And if he was, I would have thought he would have done it in chambers. So this whole thing just blows my mind. It blows my mind.
Yeah. It's crazy. I'm also astounded. I don't know what's going to happen. I don't know what juror number one's going to do. Jermaine asks, what are the ethical implications if we crowdfund for juror number one's attorney fees? I don't know. I don't think that's I would say there's probably nothing unethical about paying for somebody's lawyer fees, other than that you suddenly are included in the same boat.
Exactly. Exactly.
But I could pay for anybody's lawyer fees, if I wanted to, and legally there's not a restriction against that. But I would probably talk to a lawyer first before going down.
Well, here's the thing. Here's the thing. We know how low this defense team will go, and it wouldn't surprise me that anybody that donated will get dragged into this mess. I mean, look, I got dragged into the mess because I sat next to a woman that did not identify herself as being the juror's wife.
Right.
Not ever. She didn't and to my knowledge, she did not identify herself to anyone. Yeah. So, and I got dragged into this.
Yeah. I don't know. This is I think you're right. Anybody who does contribute financially is probably going to. There's a paper trail, and I don't know how far the attorneys want to go to dig to see who's behind what, but that's a possibility.
Now, what about these two lawyers? These outside lawyers? What are they showing up for?
They're from Maryland. They're from headquarters, I believe, J Hatch. And they probably get involved because of the IJ thing based on the timing. So they want to come in and talk about the IJ from a corporate level or argue this and practice on a corporate level. But apparently they didn't follow the right process. If we believe what Greg said in his thing, because they didn't pay their dues to the bar. I guess you have to pay to play a little bit if you want to practice out of state. Didn't file their motion the right way. So it sounds like they either have to refile it and do it correctly, or they're not going to get in. And apparently they lied if they said it was an uncontested motion for them to practice when it was contested.
All right. Do you honestly think, because you and I might have to agree to disagree on this point, since the judge is doing this interview and possibly will be allowing the defense to ask questions, do you really think that he is going to apply any type of sanctions to them at all? I don't think so.
I'm holding out that I think he will. I think he will, but he's going to wait for the right time. Jules, I've got to take another call. Thank you. Thank you so much. Appreciate talking to you.
All right, Scott. Have a good night.
We'll see you.
All right. Bye-bye.
And I lost it at the wrong time. Sorry about that. Call again. We'll try again. It said suspected spam, but I know it wasn't. It was on the burner phone. Let's see. So apparently the strike leather guy is a medical malpractice lawyer. This is his deal. Let's take a few more calls. See what you guys think.
Cindy.
Cindy, is it? How are you doing? This is RA.
Yes. Oh, hi, Scott. Yeah, this is Cindy calling in for the first time from not so sunny because it's after dark in St. John's, Newfoundland, Labrador.
All right. Wonderful, Cindy. What's on your mind tonight?
So I wanted to just call in because talking about the lawyers that are trying to come down from Baltimore. I said it in chat earlier, and I do really think it's a bad look for Johns Hopkins headquarters trying to bring in these big guns from up in Baltimore, because they really should be trying to distance themselves with this verdict, with the look that Jay Hatch, they should be distancing themselves big wide berth as much as they possibly can.
Yeah, this was an opportunity for them to say, hey, we brought on this hospital, because they did. They bought that hospital and brought it on, and it sort of retained the initial leadership. After the IJ came out, there was a clean sweep, and they could have changed it all up. And here they're like closing ranks. It appears they're closing ranks and saying, no, none shall break through this impenetrable fortress. But yeah, they're fighting hard on this one. Uncivil Law, says, stream as long as you like, but I can stream as soon as you're done. Love you. All right. Sounds good.
Oh, God bless him.
Kurt already did 4 hours today. So he's putting in the hours today.
Oh, my goodness. Oh, yeah, he's getting in the work, but I can see with all of this, he's got a lot to say.
Yep. Cindy, thank you very much. We'll probably take a couple more calls here before we wrap up, but it's good to hear from you. Thanks for calling.
Yes, excellent. Thank you so much. Have a good night.
We'll see you. Bye.
Bye.
Call from
P. Will for real.
P. Will for real. How are you doing? This is Recovery Addicts. Welcome.
Hey, Scott. Hope you're doing well.
I am.
I just had doing good. I just had one thing I wanted to, bring up.
Mm-hmm.
Yes, we all love Maya, and I think we all, we're on her side. But just to play devil's advocate, if we all, if we knew that there was the juror's wife that was in the courtroom, that she was in favor of John Hopkins, how would we feel about that? How would we feel? Because I feel like that is we love Maya, but at the same time, I would feel very different if Maya had lost. Tell me how you feel about that, just to play devil's advocate.
I tell you, it's hard to say. I'd like to be able to say that if the shoe was on the other foot, that I would be just as outraged, right? I'd like to be able to say that my morals are that pure, and I'm guided so much by principle that if I was in the other side, that I would be just as outraged. So I'd like to think that, but I have always advocated for a fair trial. I believe that there should be a fair trial, and if there's anything that wasn't fair about this, it needs to be redone. And I'll say that, but I will say that from my vantage point, I haven't seen that there was something unfair about this. That it looks like
me as well.
It was proper. So
I agree. I just try to play a devil's advocate and just say, hey, what if it was on the other foot? That's all I had to say. Because sometimes we get caught up in our confirmation bias.
Yes. We like to hear what we already know, right?
Exactly. But I'm glad that you kind of see that as well. That's all I had to say.
Yeah. Well, people, for real, thank you very much. That's a good practice all the time, to stop and think and put ourselves in somebody else's shoes and look at the same problem from the other perspective, and say, is there something we're overlooking? Is there something we need to look at from a different vantage point? But thank you very much, P. Will. Thanks for calling.
Have a good one, man.
We'll see you.
Bye.
Bye. Aaron Blackman says, I think the judge is very well thought out, not as well as Judge Doro, but close. I think this is to stiffen sanctions and protect appeal. I think you're right on the protect appeal part. I think he erred on the side of protect appeal. Judging just by what I think the judge wants to be an appellate lawyer. I think that is the career path he's headed to. Amber, I've got you on hold for just 1 second. Hang on. He wants to be an appellate lawyer. And he's working towards that, and a decision being overturned by appeals doesn't look good on any judge's record. So I think he put more emphasis on making sure this looks good, and there's no reason for appeal court to look at this than there is cause to proceed with this juror interview. Amber, what's on your mind?
I've got a lot on my mind, but I'm going to keep it classy for the RA show.
Appreciate you making that sacrifice.
Absolutely, anything to help the channel. So the only thing I really want to address right now is the chat. Please do not start blaming anybody for talking to whomever in a courtroom. This is nobody's fault. Please do not place blame on people in the chat.
Yep.
And please make sure you're not inciting people trying to go do things that would qualify as harassment. That is not what this channel is about.
Yeah, that's a quick way to get banned on this channel. I have never been a fan of jailhouse justice. I've never been a fan of canceling people we don't agree with. I'm all for voting with your dollars, but let's do everything legally and above board. We can take the high road even if other people take the low road, and that's something we'll always support. Thank you, Amber.
Not a problem. You might want to give your little plug about how you do with GoFundMe, because there's a lot of people in chat saying they want to create a GoFundMe. Please exercise caution, people, when trying to donate to these things.
GoFundMes are very tough to set up. And I wouldn't do it unless you understand the tax implications of what you're about to endeavor and the legal implications of what you're about to endeavor. So just be careful. I would with all GoFundMes, it's always better to have them created by the person who's the recipient than by an outside party. And it's very difficult to authenticate everything that way. So that being said, our platform really isn't a GoFundMe platform. That's not what we do. We're not doing that. If there is a cause that a lot of people in chat are very interested in, and we find a way to, at least as best we can, verify it, we may at some time share it, but even that is very limited. I will tell you that that almost on a weekly basis I have requests to share GoFundMes that I do not share because I'm very cautious about that. It's very difficult to proceed down that route and vouch for them. So that's all. Let's see, Misty Beard. Amber, thank you so much, by the way. Thanks for keeping it classy on the phone call as well.
Absolutely.
Have a good night. Thanks for your help today. Misty Beard says, if Jay Hetch called in, what would be your number one question you would ask and want answered? Man, I'd want them to tell it from their story. I'd want them to succinctly say, I would say basically that the plaintiff says you don't get it. that you don't understand, that you've missed. You're still not understanding what this is. What, if you look at these facts, describe it to me. What makes you in the right in here? Can you tell us from your perspective why Jay Hatch is the role model for how you should handle a situation like this? I'd want to hear it from their side of the story. Just not all the evidence and facts and things like that. Just boil it down for me. Let's see. I am a human being. I reserve the right to make mistakes, as I regularly do. Let's see. Ivan, I hit the wrong ding button. I'm so sorry. It was not intentional. I promise, says Amber. I think Ivan just got a timeout, unfortunately. He granted the interview. Did he say anything about the IJ report? No, Gypsy. As a matter of fact, he said he's not going to rule on anything else until after this interview has been decided. And he told us that on Friday in the hearing I was down there for. So once this is decided after January 3rd, then the judge will address the other issues, including the sanctions, including the remediature, the motion for new trials, all of that. That's going to all be handled later. Judge is going to screen any questions from defense or plaintiff's attorneys and will only ask those he thinks are within his order. I believe that's right. But the judge often, as judges do, very rarely do you have a judge who just walks into court and knows what he's going to do. They'll listen to both sides. They'll listen to the viewpoints of both sides, and they'll form their own opinion based on the motions and the points that are raised by counsel. And so in this case, I think it's wise for him to say, I'll ask these questions that I see were pertinent from your motion, but I also want to make sure that if there's anything else that's pertinent, and if I deem it so, we'll ask those questions as well. I think that's smart judging, even if I don't agree with the premise that he granted this motion on. If I could ask Shapiro a question, it would be, what's one thing he would like people to understand from his perspective? All right. Let's see. New law about DCF is coming January 1. In what state, or is this federal? I've often wondered, says AC's Wildflower, I've often wondered over the last few weeks how people could watch the same trial and have such vastly different perceptions of the trial. AC's Wildflower, this vantage point, that idea, that thought, never lose that. Never lose that, because the moment we prejudge something, and so as soon as we walk in, we know we're right, and we discount anything else anybody else says, we lose the ability to learn, I think. We lose the ability to find compromise and to find error in our own thoughts. But being able to stop and say, let me now look at this from the other side. Let me see how they feel. Let me put myself in their shoes and walk for a mile or so. Let's see. Florida DCF law is no more privatized. That's going to be a big change. Samantha Terry, yes, points out that on Discord, which is right here, you can find all these documents and many, many more for all the fun cases you're following. Hang on, I have to sneeze. Gesundheit. Let's see. It can be hard, Lois. It can be very hard, and I'm not good at it. Not good at it, but I do try to. There are times that I'm laying in bed, staring at the ceiling, thinking, am I right? I realize I rehash in my head the conversation, the viewpoint that I shared, and I'm saying, am I sure I'm right? Because there are some other people that came against me and had a couple comments that were really good, and they're pretty sure they're right. So that's good. Lois, thank you very much. Tammy Duncan, thank you for the super chat. I appreciate that. Love the picture of the cat as well. I just went out and bought a lot of cat food. Sorry, Mrs. R.A. I bought like 25 pounds of cat food, which is the most I've ever purchased. But I did notice that buying 25 pounds of cat food is just as cheap as buying 5 pounds of cat food at another store. So it all works out. And our cat likes this food. Anyway, Terry, your last name is going to trip me up here. Selexi. I can't say your name, Terry. I can say your first name, and that's it. I apologize. This was foreseeable. Anderson should have stuck with his instinct to remove this guy. Juror does not want or deserve this, though. So Mr. Anderson did almost vote to remove this juror. It was so close, but it was actually his client's decision to keep it. That was Jack's decision. My cat's destroyed my Christmas tree today. I've heard they like trees, that they'll climb the trees and just knock the ornaments down. Hope always says, Recovery Addict, I'm in the process of trying to teach my 19-year-old son this exact concept. Try to see another's point of view as well. Never have a closed mind. That's why Hope Always, here we always have the policy that as long as you can share it respectfully, we'd love to hear opposing opinions. We just ask that there not be name calling and nastiness in chat. I'd love to hear where I'm wrong, because I'm frequently wrong, and usually if you can point that out to me, I'll try to at least see it your way and see if I can shift my brain a little bit to come to that realization. A private citizen volunteered, says Mama Ames, and did his civic duty. Now he's been and continues to be harassed. If it can happen to him, it can happen to any of us. Trish says, mistake, cats will not eat stale cat food. This cat will eat 25 pounds of cat food in like 2 weeks. He's a big cat. Not really, but I think I'm feeding all the neighbor cats as well, because we fill up his bowl, and it's very, very empty in the morning. Let's see. We do have time for a couple more phone calls if you'd like. The burner phone is open right now. Let's see. Listen to the other side. It sounds like they're confident that Beata was the danger and J. Hatch saved Maya. Strikes me as victim mentality, always trying to be the saver. You're probably feeding possums and trash pandas too. Most likely. J. Hatch would have done the same thing to a different juror. They played dirty, says Misty Beard. I have seen some evidence that, in my mind, supports the argument that they play by rules that are a little bit different than what I think is right.
Mr. Ivan.
Ivan, how are you doing?
What is going on here?
Oh, a little bit of everything.
I feel there's a conspiracy. I've already filed with Mark Tinsley for unwarranted timeout. Amber's been named. You've been named. And Adam has been named just because. And
I timed out I timed you out for 1 minute earlier today. That was me.
Really? I didn't even notice that.
But you said something about, I want a sign, strike me, give me a coma or something. It was some prayer you were offering, and I struck you with a timeout saying, here's your sign. But that was it. Oh, man. I have to ask you, when it comes to this juror interview, Ivan, what's your thoughts? Did the judge do the right thing in granting this interview?
He has to. I think he has to. Just because I think he's throwing a bone to a dog that has no teeth, if that makes sense. Because if he doesn't do it, I think he's just trying to sort of take the short way or the long way to the short way, if that makes sense. He's just trying to give them what they think they want, just so he can crush them. My dad always said, if you want to really destroy your enemy, this is one of my dadisms, and I know some of the chat loves my dadisms. Mm-hmm. My dad always said, if you really want to destroy your enemy, give them everything they think they want. If you know they're wrong, and if you know they have no merit, give them everything they think they want, and then crush them. That's my dad's advice.
I don't see Judge Carroll as being leading them down a path to spring the trap on them. I can see him bringing the hammer down on sanctions on what's filed, but I don't see him really just reigniting the passion that he had when he was telling Ms. Carell's exactly what documents they needed to turn over, and how he would not hold it lightly. He would not look on it kindly if they withheld anything. I don't see that passion coming back out from him against the defense, at least on the IJ stuff. But.
Well, I don't know. I for some reason, and Lord knows I've been wrong before, but I think this is because there's many in the chat who have felt that the judge has sort of been way too lenient or way too sort of forgiving or way too accommodating to the defense, and I think he is reeling them in, you know, like a 30-inch muskie. I think he's reeling them in, and then he is going to hook them at the very last minute and show them exactly why they should not have done what they have done. And I guess that maybe that's wishful thinking, and maybe that's just too Northwoods metaphorical for people. But
Ivan,
I think
you had me at 30-inch muskie. You had me at 30-inch muskie. Ivan, thank you for your call. It's always wonderful talking to you.
Bet.
Have a good night. We'll see you.
Love you. Yeah, bye.
30-inch muskie. That's an ice fishing term. You know. See, this sounds like a $200 million Hail Mary, says Matthew Harris Law. They're hoping, they're praying, but you've got to realize that if for some reason, let's say that the defense is right, okay, that they sniffed out a rat and they found out that something nefarious was going on among the jurors, and they found it and identified it, and it's going to come out in this
Call
interview.
from
Mark.
If that's the case, hey Mark, hang on just a second for me. Let me finish my thought. All right. If that's the case, then this goes into retrial, right? And it pushes it out, and that's awful for the family. Let me tell you, it's awful. It's awful for the plaintiff. But then when it goes back to trial, everything we've gained and learned about the IJ is included in the new trial. And they don't want that either. I don't think they want that either, because that looks really bad. Mark, what's on your mind? Thanks for waiting for me.
Hey, Scott, how are you? Merry Christmas.
Well, same to you. Merry Christmas to you. I'm doing well.
Yeah, you bet. So along the lines of what the last caller said, I think this isn't so much a setup to get them, but I think this is to give the defendant, okay, fine, you want to interview, I'll give you, we'll do the interview. The first two questions are easy. It's no and no. And there's nothing more that he can ask.
Yeah.
If he just says no to those first two. The next one about knowing Salisbury, and I had the file open and now I closed it. If you don't mind scrolling so I can see the four questions again.
I've got it up on the screen right now. It'll take a couple seconds because it's delayed. Here we go.
Yep, exactly. With Salisbury, I mean, they could call her in and say, yep, I knew him, whatever, that kind of thing. But they're not going to. They're not going to call her in and do that. And then on the third one, again, how do you prove what's in his mind or what he thinks of them? Again, he just says, no, I didn't have an opinion one way or the other. So I'm not as upset as other people because I just think the judge said, fine, I'll humor you on this, but we're just going to ask some lame questions and be done with it.
Of the four questions, number one is a simple yes-no. Okay.
Yep.
Number two is a yes-no. Number three might be a little more complicated. Number four is going to be the biggest question. Because that's going into a proceeding that juror number one was involved in. It did have potentially some DCF involvement, and because of that, he may have opinions about DCF. That may be more of a discussion and dialogue, and that's where we could get into the weeds. And honestly,
and I don't disagree. I don't disagree with you on that at all. But again, how do you prove that I'm being honest about my opinion? It's my opinion. Yeah.
If the case in that case, if they go into that former case, the FMC 2016 case, and say the facts of the case, if they come out in court, which I don't think they should, because this is family law, right? This probably involves children because it's DCF, so I don't think the facts are going to come out. It's probably sealed. But if they dig into that and they find out that juror number one was on one side and DCF was on the other, and the court sided with DCF. If those are the facts, that could be problematic.
Well, or if there's some way you can write some sort of an evil symbol using DCF, and they find out that the juror one spelled DCF with those evil symbols, I guess that's their proof, right?
Yeah. As far as the Sally Smith, the SS thing, the judge is like, nope, we're not even going to go there. Too little, too late.
And again, that's why I think the judge looked at all that stuff and said, what a joke. No, but I'll ask these questions just to humor you. So anyway,
Mark,
keep up the
thank
good
you
work.
very much.
I appreciate listening to you.
Appreciate the call. Merry Christmas to you and yours. We'll see you.
You too.
Bye. Hey, Nancy Mammy DeMay, Mrs. RA is in chat, but she is also really, really sick and on the couch wrapped in a blanket trying to stay warm with some soup. So I don't think she wants to be live just today. although I'm sure she has some thoughts that she might share in chat. But wasn't Deborah Salisbury on the other side of the court case involving Hippo Lover? I don't know. I don't know what part she played. Does anyone think this is dangerous for the juror being former law enforcement, or is it just me? I would say it would be. I would say I'm more concerned for him being juror number 1 in this case than I am concerned about him being former law enforcement and being outed. I think this has the potential for more disruption and mayhem in his life. I think that's just my personal not knowing what he did law enforcement wise. That could be a big factor. If they dig into the family law issue, then Mrs. Juror number 1 could step up to keep the records sealed. I'm not sure what the ruling is there. I think they're sealed. I don't think they can just say, hey, because we're asking questions about this, we're going to open this up in public court. P. Will for Real says, another thing I will say, I do think the wife should not have been there. Yes, she had the right to be there, but it's bad optics nonetheless. I disagree. Man, if my significant other, if my wife is involved in a court case as a juror, and I can't talk to her about it, I'm going to take work off, and I'm going to go sit there and watch court myself, so that we'll have things to talk about when she can talk to me about it. I would be there in a heartbeat. Let's see. In fact, I'm wrapped in 3 blankets. Love the softness. Thank you. And some of those blankets came from some wonderful YouTubers. Not wonderful YouTubers, but wonderful community members on this YouTube channel. So thank you. Let's see, Kay. I'm talking to you specifically. Let's see. Any other calls? Shapiro's wife was there. I believe she was. I didn't recognize her. I have opinions on DCF. That is, they are necessary but not always right. What does that say about my bias? Well, amid a W, it's not wrong to have opinions. It's not wrong to have experiences and feelings about things. But when you sit as a juror, if you have those, you have to just be aware of them and say, I'm willing to set those aside. I'm willing to set aside what my experience and listen to this fairly.
Call from
AWOL.
Is this AWOL? How are you doing?
Yes, it is. How you doing, Scott?
I am doing just great. How are you doing this evening? I mean, what's on your mind this evening? I asked you that already.
Merry Christmas.
Merry Christmas to you as well.
I'm doing good. Thank you for asking.
Good.
I feel like I don't mind. We're all on my side here. Mm-hmm. I am, at least. I don't want to speak for everybody, but I am. Mm-hmm. But I don't mind that the juror interview was granted, because we do have to exhaust all options here. Because as far as appeals, we don't want no leaf unturned. Like, I feel like we should handle everything we can so every decision is good. We have seen court systems and prosecutors hide evidence, tamper. We have seen guilty people get off because of those factors. So if we want this system of America to be fair, if the judge decides that it is fair, I feel like we should kind of go with it, because it is fair. Let's exhaust all the options. So if the decision stands on its merits, then there are no complaints.
So
I feel it's healthy.
The judge gave a little nod to that in his motion, basically saying that that there's a need for transparency in the court system, that people can trust it. And I think for some people looking at this and saying, wow, yeah, I'd like to know what goes on. I want to make sure the judges, that this is a fair jury and everything. I would say that the people who feel that probably have never been summoned to sit on a jury.
Correct.
People who have been there or who have sat on a jury. I mean, by a show of hands, how many have sat on a jury and would like to now get called back into court and asked questions about either what you said in the juror interview, what you may or may not have remembered for your questionnaire, to see if maybe now that court case should be redone. I mean, it's scary. It's scary to have the court turn its focus from the players, the plaintiff and the defendant, to an innocent bystander who's summoned and by law has to be there, not of their own choice. So
correct, and that's sorry to cut you off, and that is a slippery slope where we have a certain level to where how our justice system works And it can be slippery if we now go down this way. Now every jury, every person now has to get their background check. Then what is the checks and balances of fairness? Because who knows what it can be. I just like the fact that in this trial, at least, and how you do your channel in true crime. I love true crime. I watched the OJ trial, came home from school, peanut butter and jelly sandwiches. Watching. Awesome. Maybe too young for it, but I loved it. Yeah. But I think that the way you do your channel, I think it's good. Hindsight is 20/20, and we have to understand that we might feel good here, but we can't be married to our ideas, because I don't think that's healthy. We have to steel man the other person's point of view. We don't have to agree, but we could do an experiment of steel manning the other person's point of view. At least it's almost empathetic to do so. And then at the end of the day, you can go, no, I still believe in what I believe in. But at least you gave an effort of trying to see the other person's side and then go, okay. And you can change your ideas and your opinions. That's fine. That's healthy. We're humans. We're tribal at the same time. But like I said, we're all on Maya's side. Big corporations, a lot of stuff has to change. Once again, you don't want child services to go overboard, but you also don't want them to turn a blind eye like the Gabriel case. Yeah. Where nobody noticed anything when they should have noticed. And then we get mad at them for not noticing it. But when they go over, it's like how you go right and wrong at the same time. I feel for them. It's a tough job to protect children. It's tough.
Yeah, it is. It's one I struggle with when we start talking about DCF and the role for them and what they should do. I'm a big proponent of parents' rights until you get the situations where, we just had in Utah with the Ruby Frankie situation. And that parent was doing things that is not right, and somebody needed to step in. So it's a very tough call, and I'm glad I'm not the one that has to make that call as well. But
you and me both.
Awal, thank you very much for your thoughts today. Appreciate the call.
Yes, sir. I will just end it off with this. Merry Christmas. Your channel is the best. Your quality and audio is the best. You're the man.
Thank you,
so much.
Merry Christmas to you too. We'll see you.
Yes, sir. Bye.
All right, thank you, AWOL. Let's see. Cases from 2022. Okay. Let's see. I'm trying to get caught up on the questions here. Have opinions on DCF, but they change with the circumstance. Sometimes they do too much. Sometimes they do too little. Yenzi, yeah. For instance, on the do too little, we had a situation with. Oh man, I'm trying to remember the cold case. It was a murder trial out of Utah, and the dad, the wife went missing, and they never found her body. The dad ended up moving to Oregon, and he had 2 kids that he had rights to visit. The state was providing the state was bringing the kids to his house to visit, and they brought him to the kids to the house. He grabbed him, pulled him inside the door, shut the door, locked the DCF worker out, and then proceeded to eliminate himself and his kids, and sort of burnt the place down. And you're like, how could they do that? How could they allow this to happen? Yeah. Okay. I don't have a Discord, my pal Sal, but there, if you type !Discord in chat, there is a Discord that we're good friends with. Right here is the link, the command, and it should post a link in chat if it's working, which sometimes it's a little busy. There it is. There's the link. You can go to Discord. This is As the Gavel Drops. These are friends of the channel. They run a true crime Discord that tracks documents, tracks cases, tracks calendars of all the true crime cases you're interested in. So if you're looking for documents, there's a one-stop shop right there that can help you out. And all the great people you see here are there as well. All right. Let me get caught up here at the bottom. The CPS worker was actually on the phone with 911 when he blew up the house. Yes. First, why can I remember Susan Powell? That's it. Susan Powell. And Josh Powell was the guy's name. Lots of searches went on there. Cold, that's the name of the podcast. Spectacularly done podcast on the Josh and Susan Powell case. If you like cold case podcasts, this one is the best out there I've ever heard. It is the best out there. It's called Cold. It's about the Susan Powell case. And the access they got, oh my goodness, the access they got was unprecedented as far as evidence and documents goes.
Call from
Bree.
Bree, good evening. This is RA. How are you doing?
Good evening. I got late because I was at work. So I have a question for you because I don't really understand because I might miss part of it. I know you said that they're going to grant the juror interview and then he'll make a decision for the other stuff like IJ and the other things after this interview. Why the interview first to make those decisions? We know they didn't turn over the documents and we know that there was stuff they didn't do. What does this interview with the juror have to do with them still not doing those things?
Well, if the interview with the juror turns up that there is a problem, then that means there's a mistrial. There's a new trial ordered. Okay. So then you don't have to address the remediator of lowering the verdict amounts because we're throwing everything out and starting over again. Also, some of the other factors that really don't become as pertinent. They might be important, but can be addressed later on. Say like the IJ stuff, it'll probably come up in the next trial, and that'll be pursued later. It might not have to be urgently handled right now. And so he says the most pressing issue is this juror interview. If he grants that, then after that he'll make all the other decisions.
I guess my thought is if they really withheld information that the other side needed for a fair case to begin with, it shouldn't matter if they felt the juror went and talked to his wife or not. They shouldn't have withheld this. There should be sanctions, and we should be leaving this alone because if they would have done it right to begin with, we wouldn't even been here to begin with.
Yeah.
So
Lauren Farmer,
I appreciate it.
Thank you very much. I was going to say Lauren Farmer just announced that Hunter just paid the court fees for the Prohack Vice. That's the plaintiff's motion to get these two attorneys from Maryland to practice in Florida. So he just paid the fee. I'm not sure if that's going to be enough, but we'll see. Thank you very much for your call, okay. Bree. I appreciate it. You've always
I appreciate
got great questions.
Bye.
We'll see you. Bye. It seems a little bit like J Hatch is tagging somebody in. It's like a group wrestling thing where they tag in their teammates. Like, hey, we're getting our butts whooped here. Come in and save us. And they tag some fresh faces to come in from headquarters. Let's see. Lauren says, I just emailed it. Thank you very much, Lauren. I'll take a look at that. But I do believe he did pay the fee. It's funny that he didn't until then. Thank you again for being such an asset, says Cachette. Oh, thank you. Cachette, kind words, always. Appreciated. The Viche. It's Viche, says Becca Lynn. I'm pronouncing it wrong. Do you know why, Becca? It's because I never went to law school. I just love the law. I don't know how to pronounce anything.
Nancy.
Nancy, this is RA. How are you doing this evening?
I'm doing okay. Thank you, Scott. Merry Christmas.
Merry Christmas to you, too.
I just have one thing. If they don't show the juror's face, but he's still got to give his last name, so people are still going to know his name when it comes to doing jobs or whatever. I mean, I have friends that are retired cops, and they've gone to work after that to other places.
I know. I think the judge might be saying that his name's come out already. It came out because, in my opinion, because of the defense filings.
Right, I saw that.
That opened that door. But I don't think the juror, through any action of his own, has announced, has identified himself publicly, right? Even though he said, hey, I'm juror number one. That's the level of anonymity he keeps. He says, I am juror number one. That's how I want you to refer to me as.
That's what I've seen, yep.
And he's been very cautious. So this would be the next level of outing him by, with his image and everything else. So I hope the judge at least respects that. He has already been doxxed, but still, it seems like why do it again? I mean, sometimes some of those documents that doxed him have been redacted since then. So it did have some exposure, but it was limited. Why dox him again because someone else did it previously?
Right. I don't know. I just feel bad for him, and because, I like I said, I have friends that are cops or was cops, and I was talking to them about it, and they're like, "No way, you won't get a job." It's if he's working or going to look for a job, whatever. I don't know what he's doing. So,
yeah, it's frustrating. This whole process is frustrating. I realize the judge is trying to do the best he can in this situation, but I think I can't but think that his decision was influenced more on what this might look like for an appeal than for what this looks like for the juror, and for all jurors going forward.
Yeah, I wish I was living in Florida still. I lived down from there, maybe an hour and a half. I would go to this hearing. I would have gone to all the courts.
Yeah.
And, but I don't live in Florida anymore, so I can't go.
I have to sort of be careful what I say about the judge because I still have to apply to him to get media access for this next hearing on the 3rd.
Exactly, yeah.
So Judge Carroll, I love you, my friend. You are the tuft of justice, as other people have called you.
All right. Thank you, Scott. And I tell your wife to feel better.
Will do. Thank you so much. Have a good
night.
Merry Christmas.
Yep. Bye-bye.
Bye.
You too.
All right. Let's see. Ivan, did you get timed out for real? Is it like I don't see you in chat, so I'm thinking you might have been timed out. You don't need to call. It's all right. I'll look it up. All right. I'm not sure if Matthew Harris or Uncivil Law wants to call. Oh, Uncivil's going live right now, right? I think he's going live right now. So, is he protecting against appeal? I think that's what his main focus is. Juror number 1 needs to talk to Papa Tragos. I got a lot of respect for Peter Tragos. I do not know his dad. Obviously, probably a very, very good attorney. I think Peter sort of steered clear of this for a while because this is in his backyard, and it's as someone who comments on cases, he has to be careful because he's commenting on people that he may practice in front of or against. And that's just something that you'll find all lawyers are very cautious of, just out of respect for the process and the people. So, juror number 1 can't sue the defendant lawyers, but what about his wife since she's no part of these legal proceedings? I could not answer that one. She'd have to get some legal advice on that one. I don't even know if she has grounds for that. Okay, let's see. I think Amber's calling back in. Amber, welcome back.
Hello. I have calmed down just a little bit. Ivan, I'm so sorry. It was really a mistake. I'm really sorry.
What did you do to Ivan?
I accidentally timed him out for 30 minutes.
Oh, 30 minutes. 30 minutes isn't bad. He's had much worse for me.
At least it wasn't 24 hours.
Ivan,
I'm really sorry, Ivan.
Chat goes so fast, and the options are so close together. It was an accident. We're very sorry.
But I kind of wanted to give you my take now that I've kind of my blood pressure and my pulse rate is back to normal somewhat. I think everybody's kind of touched on it. Are we happy about it? No. Did we expect it? A lot of us did. Because you've got to put yourself in Judge Carroll's shoes, right? You have to make these calls on a neutral basis based off of what the law tells you to do, not how you feel what's right or wrong. It's based off of the law. So just as he said in that order about the IJ docs, about a scintilla of odor,
right,
relating to the immediate jeopardy findings of any kind. It's the same principle here. We may not like it. I am not a fan of it, but I can appreciate that Judge Carroll is trying to protect the case from going, like, this being a ground for an appellate issue. So,
and this case was always going to go to appeal. I mean, this
right.
isn't. He's not trying to keep it from ever going to appeal. He knew it was going to appeal, and because of that, he wants to keep it as clean as possible. Because
right.
This case is the first time I think ever that we've had the damages and the charges tied in with a fault for unaliving oneself. The way this case did it, this was groundbreaking, the way they handled it in this case. So it was always going to be appealed on that fact alone. And I think the judge is trying to keep the rest of it, cut all the rough edges off, so it's nice and smooth, and that issue alone can be addressed by the appellate court.
Right. And if I remember correctly, the appellate court case was actually opened in 2020. I already have all of the appellate case information. It's been in existence since before this case was set to go to trial, because they knew it was going to be such a big issue.
They've had dedicated lawyers just for the appellate case from the whole
very
trial.
Beginning. Yeah. It may not have been 2020, maybe it was 20. It doesn't matter. They have already filed the appellate case and have a case number that's years old. So when we're discussing how we feel about this and what this means, a lot of that's coming from an emotional place where Judge Carroll can't rule from an emotional place. So if we step back and breathe for a second, look at what he's doing. He's trying to make everything clear and concise to where there's no possible scintilla of odor in question about juror number 1 and the alleged stuff. So give him some grace. Yeah. I mean, we don't like it, and we feel it violates a lot of things. A lot of us do. So we've got to trust the process. You either believe in the system or you don't.
This is the biggest one, though. The biggest one is we've always held that juries are protected, that their names are kept from the public records, that their faces are not allowed to be shown. Yes, you can walk into court and see them. But there's always been this umbrella of protection that's encompassed and protected the jury, and now that it seems like this pierces that protection. And I realize this law has always been there. I mean, I don't know when it was founded, but this is case law they're citing, so this has happened before. But it seems to be an affront to justice to allow this to go on, And maybe that's because our perception of what the protection the jury has is incorrect. But I don't think it's going to be the end of the world. I think it will be very limited. I personally think that this interview will amount to about exactly what the plaintiff thinks it will, which is nothing. And then we're going to move on. But at the same time, I'm mindful that just holding the interview does cause damage, and that everyone who watches this trial. And there are a lot of people. There was a lot of interest in this Maya trial. Will know that jurors might be dragged out and held under the microscope after the fact, if they don't decide the way one party thinks they should.
But that's also unfair, though, too, because there's always been the potential, right? The potential to request a jury interview for suspected misconduct. If they can prove a scintilla of odor, they have at least a pinky toe to stand on. So how would we feel if Judge Carroll had denied this juror interview and the appellate court overturned the entire trial and said, no, they should have done a juror interview?
Yeah.
How would we feel then?
And that's what the judge has done many other times. He said, I'm looking at this from an appellate standpoint, and if I handle it this way, then it will answer the question for the appellate court. I think no one's going to appeal. The plaintiff is not going to appeal based on the fact that there was a juror interview. So that's not going to be an appellate issue in and of itself. But if there isn't a juror issue, it could be from the defense. So I think he's smart to do it that way a little bit from the appellate viewpoint. I will also say this, I don't know. I feel it does harm the jury system. I feel it does. I don't think there was enough evidence presented to say, yes, that the law is specifically written to say there are very few instances where we will authorize, where the court where you can say, yes, let's go ahead and grab one of those jurors and drag them out and put them under the microscope and ask them the hard questions. And to do that, you have to prove a certain level of problem occurred. And I don't think they did that. So I'm disappointed that we're at this point already. Amber, I'm gonna wrap things up here in just a minute. I wanted to let Kurt know I did redirect to his live stream. I know he's going to be talking about this from a legal standpoint. If you want some, I will say probably some angry words, because I think Kurt has a few words that he was kind enough not to share in chat, but he might share on his stream. A little bit of frustration about this situation, as he was one who was vocal about that it was inappropriate for the judge to go this route, that they should not go this route at all. So we'll hear some comments from Kurt tonight about that. I know he's holding off here. We're gonna patch over to him briefly. We're gonna jump to him when we're done.
Sounds good to me.
There was one other thought. Thank you, Amber. Have yourself a great night.
Appreciate
the call again. There was one other thought I had. Let's see. This judge tried to walk the straight and narrow in this case and is biding his time to get past all appealable matters as best he can. I think that other thought is that in that we've seen the judge now order a limited juror interview, and a lot of us are upset about that or thinking it's not right. But now that he's done this, I think more so than ever, I think in being fair to this entire case, I want him to put the thumb screws to the defense on the IJ and not let go until every single page has been turned over and been examined by the plaintiff. I think it's only fair if you allow the defense to dig and fish for information like this, where there's no evidence of a wrongdoing, that where in the defense's case, where I believe you could say we have evidence of wrongdoing, it would be wrong for the judge to allow them to withhold those documents about the IJ. That they can say, oh, that's privilege. That's privilege. We don't want people to see that. Our papers? No. He's got to put some backbone behind that and say, I ordered it and it's going to happen, and I'm going to drag it out of you, and there'll be sanctions if it doesn't. Even I'll say it, contempt, and everything that comes with contempt of court. All right, their rant is over. We are done. Thank you tonight. Has been exciting and frustrating all at the same time, as we find out that we have another hearing coming up on the 3rd, which is when we thought it would be. The judge, just as a recap, the judge did authorize a limited juror interview with juror number 1. He is not allowing a forensic analysis of the juror's phone, of the juror's wife's phone, of Jules' phone, or even the burner phone, even though they didn't mention it. I think that was included in there just by association. But there's going to be no forensic evaluation of phones. The questions that are going to be asked of the juror are very limited. They're on 4 topics. And most of them are going to be very brief. I think one might be a little more in-depth about the prior case involving DCF, if there was any involvement there. But that's it. And that's all going to happen on the 3rd. We've got the date now provided for us. It's going to happen in the same courthouse that the last hearing happened with on Friday. I'll talk to Mrs. RA and see if Florida's in the cards again for another trip for 1 hour. We'll also have to make some filings to get included in the media access on that. So we'll do that. With that said, I think that's it. Let's go ahead and call it quits for tonight and go back. Remember, tomorrow we're continuing the case that we've been following out of the record books. It's one from a couple of years ago with Judge Newman. It's exciting. It's fun to see Judge Newman in his court. This happened all before Alex Murdaugh. But we're about 3/4 of the way through that case. I think we will be tomorrow. We're going to finish the whole thing this week. So if you want to join us for that, it's a fun one. It's sometimes frustrating. A lot of DNA evidence. Lots of zeros shared today. Lots of zeros. Almost as many as the J-Hatch team has to write on their check. Lots of zeros. Anyway, tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again, which will be tomorrow morning about 8:45, I'm thinking. 8:45. Meanwhile, we're going to go over and join Kurt on his live stream. Kurt's going to be tearing into this again from a legal perspective. He's going to be sharing his opinion, which he carefully bit his tongue and limited his speech in our chat. Thank you, Kurt. Appreciate that. Kurt's a friend of the program. As always, I'll tell you that all the people we pass you to is not me. So if you go to his channel expecting to find me, I might be there in chat, but we go to Kurt's channel because we get Kurt and we get his analysis and his thoughts just like we go to Rob's channel to get his, and we go to Brandy's to get hers. So thank you. If you're going to join me over there, I look forward to seeing you over there. Kurt, it's going to be a fantastic stream tonight. I just can't wait to hear your spiciness. It's going to be good. Everybody be good to each other. We will see you tomorrow. Have a good one. Bye.